conservative nonprofit called America First Legal, founded by former Trump advisor Stephen Miller, filed a federal civil rights complaint against the NFL, arguing that the Rooney Rule is itself discriminatory and therefore illegal. We couldn't get America First Legal to speak with us, but we did have a conversation with someone who takes a similar position.
The Rooney Rule, or anything that aims at quotas, headcounts, whatever they want to call them, doesn't do the hard work, the necessary work, the important work. And that's why they so fundamentally make things worse, even when they're good-heartedly trying to make things better.
That is Scott Shepard.
I'm the general counsel at the National Center for Public Policy Research. I was also the director of the Free Enterprise Project, which is our center's project that for about 20 years has recognized the leftward drift of corporations and has been the shareholder proponent trying to stand athwart that hollering stop.
In order to be that shareholder proponent, Shepard's organization buys stock in the companies it wants to monitor. And how much stock do they need to buy?
One share if we want to try to make a comment at a shareholder meeting. But to submit a shareholder proposal, the floor is very low. It's only continuously owning $2,000 worth of a company for 3 years without let-up.
And how does Shepard see his organization representing the interests of the shareholders?
We are fighting the breaches of fiduciary duty, and particularly the breaches of fiduciary duty arising from partisanship, from directors and executives taking their eyes off the ball and getting involved in completely unnecessary, completely unrelated to core business, partisan controversies that are guaranteed to upset lots of people, to have high potential risk and not much upside. When things are good for companies, no behaviors have to be forced. If discrimination on the basis of race, sex, and orientation were good for corporations, corporations would have been figuring out a way to do it on their own.
So your argument is that if it were good for the business would be doing it because they're competitive people in a competitive marketplace and so on. Let me port that argument over to the NFL. That's a very competitive environment. It's a league where there are really just 32 stakeholders, and they really do run and own the league, even though the league, acts as if it runs them. And they're all obviously competitive. They want to win on the field and off the field. Would you say the same is true about them, that in order to optimize their chances of success, whether it's on-field victory or business, that they would inherently hire the best people and that they're not leaving any good overlooked talent behind?
Well, I have to preface this by saying I was a tiny little boy in the 70s in the center of Pennsylvania, so I am, I think, legally disbarred from saying anything unpleasant about a Rooney. And I won't, because I think that Dan was, we're not on a first-name basis, I think that Dan was kind of heart and good of soul and recognizing something that was a real, true problem and a problem of discrimination in the NFL. You can't possibly have the numbers that he recognized without there being some genuine systemic internal discrimination, I should think. It was a careful move. It was thoughtful. And I think that it was the right place to try something like that.
It sounds like there's a but there that you haven't gotten to, but you're either unconvinced that it was the right move or you think it's gone too far or what?
All discrimination on invidious grounds, race, sex, orientation, is wrong and leads to bad consequences for everybody, but particularly the people on whose behalf the discrimination supposedly occurs. Because once the Rooney Rule's in place, then every black interviewee has the question mark hanging over his head. Is he, or maybe someday she, legitimately there, or are they being used as a token? And once that stain arises, everybody's tarred. Justice Thomas has talked about he having been tarred. So I think it runs everywhere.
Do you think the Rooney Rule is unconstitutional?
Well, I think that the Rooney Rule, as applied by Dan Rooney, when it was and how it was, might be. But when there's direct proof of past discrimination by a specific organization, they can take some steps consonant with the Constitution to rectify those specific deeds. I just genuinely don't know what the courts would decide about the constitutionality, but once you hop outside of the NFL, it is absolutely and unequivocally unconstitutional.
If I were to ask you what share of, let's say, the 500 biggest companies in the U.S. are engaged in what your organization would consider illegal DEI practices, What would that number be?
If I could add a probably, or it's our best evaluation, I would say something above 75%.
And give me some evidence of what makes you think the number is so high.
Well, our first bin of evidence is the gleeful declarations of discriminatory and unconstitutional behavior that so many corporations engaged in during the lockdown, the protests and riots, the George Floyd summer of 2020. It seems that everybody being at home, there were some miscommunications. And so certain departments just announced things that an objective legal department would have said, no, let's not admit to that out loud.
Give me a for instance there.
Here is a program that I'm certain that lots of companies, A, engaged in, and B, were proud to announce at one point. I think they've probably wiped all of that now. A lot of thought went into fairly sophisticated efforts to actually discriminate without triggering the constitutional bar. It worked in three parts. The first part was a diversity dashboard. Executives and directors who had the authority to hire, promote, make other human resources decisions knew the surface characteristics or private characteristics of everybody who reported to them. And then they set, and companies were very careful about the word, although not the content, just goals, not quotas, for what sort of surface or private characteristics were meant to be achieved. And then, and this is the real clincher, those actors got bonuses if they hit those goals, not quotas.
And that would be illegal. Why exactly? Why specifically?
It is illegal to discriminate on the basis of race, sex, or orientation, even if a company's made it more difficult to discover just where in the process the actual discrimination occurred. And we think that these corporations using this system made their problems much, much worse, because you can be harmed by illegal discrimination even if you're not a member of the class at whom the harm is directed. For instance, if you've got a person with hiring authority and it comes down to them to both make the discriminatory decision and to black box it, well, the incentive structure that's been established creates exactly the incentive for them to discriminate on the basis of race, sex, or orientation. And so it's a hostile work environment for them as well as everybody else.
I understand you were part of a lawsuit against Starbucks CEO Howard Schultz and the company's officers and directors. Walk me through that, would you please, Scott?
Sure. Our claim at base was one arising from fiduciary duty, as well as the Codex of Civil Rights laws. We said, and this is, I think, fairly clear black letter law, directors and executives may not take any action that violates law. And in other contexts, directors and executives rely on that obligation fairly heavily. But discriminating in the ways that Starbucks was discriminating, and they were using that tripart structure I just...
So this is the hiring component of Starbucks you're talking about, yes? Or other personnel issues or compensation? What did it include?
We had 6 or 7 different examples, and they extended beyond hiring. I don't recall right now in what directions, but it seemed like, and this is, I think, a fairly telling word in this instance, it seems like fairly systemic race, sex, and orientation discrimination by Starbucks. So we brought suit in district court against not the company, but the directors and executives. And the luck of our draw with a district judge.
Yeah, the judge didn't like your case at all.
No, but it's interesting. The way I read his decision and opinion, he didn't dismiss on the grounds of any demonstrable law. In fact, one of the positions he cited, one of the things he indicated backed his dismissal and opportunity for Starbucks executives to try to sanction us, which was fairly unusual, was that, we're shareholders. If we don't like what Starbucks is doing, we can sell and buy another company. But if that's so, then the whole edifice of fiduciary duty law collapses, right? It cannot be the position of the American courts, much less a federal court interpreting state law, that fiduciary duty just doesn't really matter anymore. You can just sell your shares. And so we thought that was a very telling way of responding to that. We think it was proof of concept, and that when we get to a court more driven by obvious demonstrations of fidelity to law, we'll get different results, and others will as well.
The judge in that case cited a number of reasons for dismissing the case, including that the plaintiff, that is Scott Shepard's National Center for Public Policy Research, was, quote, pursuing its personal interests rather than those of Starbucks, and that his organization has shown obvious vindictiveness towards Starbucks and lacks the support of the vast majority of Starbucks shareholders. That said, if you think the Starbucks case was the last of its kind in this DEI era, you are almost certainly wrong.